What's up, guys? How are you doing right now, and how was the day? I hope you had a wonderful day. Thank you very much for staying tuned on this channel TV. Please, if you're just new, kindly subscribe, like, share, and then comment. Right about now, I want to bring you a fresh update on Mazi Nnamdi Kanu's health condition and other things surround it. Yeah, this evening the news I'm getting is not just a very good one. I am not happy personally. I don't know about you. Mazi Nnamdi Kanu's health is deteriorating and he has said that he may die in detention. That they should transfer him from DSS custody to Kuje Correctional Center. I don't know why the federal government has decided to do this. They should be able to treat this man with equity and fairness. But I don't know what is happening. I do not understand it. What is their plan? I don't know whether you feel what I feel. Do you think these people have something else in mind that they want to achieve? Because I don't understand. The first time they detained him, they kept him in Kuje Correctional Center where he stayed over 1 year, almost 2 years. Then what happened this time? Why don't they want to transfer him to Kuje Correctional Center? They decided to keep him in DSS custody where he doesn't have access to even his medical doctors. Right now he's been complaining about his health, which is deteriorating. My dear people, what do you think about this? Detained leader of the proscribed indigenous people of Biafra IPOB, Nnamdi Kanu, has filed an application before the Federal High Court in Abuja seeking to be transferred from custody of the Department of State Service (DSS) to the Nigerian Correctional Service Center in Kuje. Kanu, in the application he filed through his team of lawyers led by Mr. Ifeanyi Ejiofor, decried that he has been denied access to his medical doctors. He said he might die in the custody of the DSS if nothing was done to urgently address his deteriorating health condition. He specifically applied for an order of the trial court directing the transfer of the applicant from the custody of the national headquarters of the State Security Service to the Nigerian Correctional Service Center in Kuje, Abuja, within the jurisdiction of this honorable court, where he was initially detained before he was granted bail, pending the determination of the charge, as well as an order of his honorable court directing the defendant custodian to grant access to his medical experts to carry out a comprehensive independent medical examination of the defendant's health condition status while in custody. It will be recalled that Kanu, whose whereabouts was hitherto unknown, was on June 27 returned back to the country after he was arrested from a yet-to-be-confirmed African country. Okay. The Attorney General of the Federation and Minister of Justice, Mr. Abubakar Malami Sam, had insisted that he lawfully intercepted as a result of a collaborative effort of various security agencies in the country. However, Kanu's lawyer, Ejiofor, disclosed that his client was on June 18 illegally arrested at the airport and detained for 8 days by Kenya's Special Police Force before he was eventually handed over to their Nigerian counterpart. Ejiofor alleged that the IPOB leader was tortured and subjected to various forms of inhuman treatment in Kenya, a situation he said worsened his health condition. Trial Justice Binta Yako had, upon Kanu's return to Nigeria, ordered his remand in DSS custody, even as his trial on a treasonable felony charge which was initially fixed for October, was brought forward to July 26. Meanwhile, in the fresh application, Kanu alleged that he has been subjected to mental and psychological torture by the DSS, saying it will be in the interest of justice for the court to order his transfer to the Nigerian Correctional Service Center, which he described as an impartial facility that has no interest whatsoever in the outcome of his trial. An affidavit he attached in support of the applicant read that this charge number FHC/ABJ/CR 383 2015 came upon 29th June 2021, and the applicant was brought before the court in chains, handcuffs, and lead cuffs, blindfolded, and was consequently remanded in the custody of the State Security Service, even though there was no legal representation for the defendant, and the matter was therefore adjourned to the 26th day of July 2021 for trial. That the counsel to the applicant was not served with any hearing notice before the appearance of the applicant in court. Neither were they aware that any action was scheduled to take place in the criminal charge number FCH/ABJ/CR/383/2015 on that 29th June 2021. That on 30th June 2021, the applicant's solicitors formally wrote to the State Security Service to allow the applicant's solicitors have access to the applicant. A copy of the said letter is hereby attached and marked as Exhibit MNK1. That on 2nd July 2021 at about 12:32 p.m., the State Security Service called me to inform me that our request to visit the applicant has been approved and that I should come by 4 p.m. to see defendant. That on the said 2nd July 2021 at about 5 p.m. at the State Security Headquarters in Abuja, the applicant informed me of the following facts, which I verily believed to be accurate and correct as follows: that he was kidnapped and or abducted by Kenyan security forces on 19th June 2021, specifically at Nairobi Airport. That he was detained by the personnel of the Kenyan police force for 8 days and was throughout this period of detention subjected to all forms of inhuman treatment, brutal torture, causing grave and severe heart problem that almost took his life. That he was detained in an unconventional facility, not necessarily a police detention center in Kenya. That throughout this detention in Kenya, he was never allowed access to his relatives before he was handed over to their Nigerian security counterparts, who smuggled him into Nigeria in clear violation of his rights. That since he was smuggled into this country on 27th June 2021, he has been kept in solitary confinement without access to his family members, relatives, wife, cousins, and children, except his lawyer, who only visits after they must secure the approval of endorsement of the Director General of the State Security Service, which approval are not usually granted as a matter of course. That he is still being subjected to mental and psychological torture by his custodians on account of the conditions of his solitary confinement. That an ECG examination was carried out on defendant, and it was discovered that defendant's heart had been enlarged by more than 13%, posing a serious threat and danger to defendant's life. That there is a need for the defendant to have access to his medical doctors to avert the danger looming against the life of the defendant. That the health personnel attending to the defendant in the custody of the State Security Service is not adequate considering the circumstances of the defendant's health condition. That the defendant requires the services of his medical experts as his medical results records issued by the chief cardiologist of Nairobi Hospital, who has the defendant's medical records mainly before the arrest/adoption of the applicant shows a debilitating medical condition. Copies of these medical records showing the applicant's subsisting health condition are hereby attached and marked as Exhibit MNK. That if the health condition of the defendant is not addressed most promptly, the defendant may die in custody, even before his trial. It is essential that the defendant's medical experts/consultants be allowed to carry out proper, thorough, and independent medical examinations of defendant to save defendant's life. That the defendant needs regular medical observation/attention by the defendant's medical specialists or consultants in cardiology. That the defendant's medical specialists, including chief cardiologist of Nairobi Hospital in Kenya, have his complete medical results that will easily aid the examination of the defendant and treatment thereof. That the defendant undertakes to bear any cost incidental to getting the medical experts to attend to his ill health while in custody. The defendant can only be alive to stand his trial, which cannot be guaranteed because of his rapidly deteriorating health situation. The defendant cannot effectively put up a defense to the charge against him in his present deteriorating health condition. That I know that upon the arraignment of the applicant, this honorable court in its wisdom initially remanded the applicant in Kuje Correctional Service Center, where he was held for almost 2 years before bail was consequently granted to the applicant. That for the almost 2 years the applicant was in custody in Kuje Correctional Facility, there was never any complaint about any form of misconduct against him. That the State Security Service is not a detention center, neither does it have the requisite custodial facility to enhance the conditions of the occupants/inmates. That the Nigerian Correctional Service Center is an impartial facility that has no interest whatsoever in the outcome of this charge. That the Nigerian Correctional Service Center is the only body statutorily empowered to keep custody of persons facing criminal trial in courts. Hence, the necessity to transfer the applicant to the Nigerian Correctional Service Center, Kuje. That it will serve the interest of justice and enhance fair hearing for his honorable court to transfer the applicant from the State Security Service to the Nigerian Correctional Service Center in Kuje, Abuja, within the jurisdiction of this honorable court. That the applicant has very limited access to his lawyers, who can only visit him after the approval of the Director of the State Security Services has been first sought and obtained, which said approval in most cases takes days, and that the above situation would greatly impede the defendant's preparation for his defense to the charge against him. That the favorable consideration of this application is compelling in the circumstance of the present notice for the resumption of the court's annual vacation, which would affect the hearing of the substantive charge already slated for the 26th day of July 2021. That fair hearing can only be guaranteed when the applicant is not remanded in the custody of his accusers. That it is a fact that justice must not be done, but must be seen to be done. That it will greatly aid and serve the interest of justice if this application is granted. That the respondent will not be prejudiced by the grant of this application. That I depose to this affidavit in good faith, believing same to be true and correct and in accordance with the oath act. It will be recalled that Kanu was on April 25, 2016 released on bail by the court on health ground after he had spent about a year and 7 months in detention. To secure his release, the senator representing Abia South, Engineer Abaribe, an accountant, Mr. Tochukwu Uchendu, and a Jewish high priest, Emmanuel El Shalom Oka Ben Madu, on April 28, 2016, signed an undertaking to ensure his attendance in court. Nevertheless, following the disappearance of defendant after he was released on bail, the court on November 14, 2018 ordered the three sureties to forfeit the 100 million bail bond they each consented to. Likewise, the court on March 28, 2019 revoked Kanu's bail and issued a bench warrant for his arrest. Kanu's lawyer had protested the revocation of his client's bail, insisting that his disappearance was occasioned by the unwarranted invasion of his home at Afaroku in Abia State by the Nigerian army. A development, he said, led to the death of many innocent persons that were in the compound at that time of the invasion. My dear people, is there anything you do not understand here? The whole thing is just very clear. I would like you to drop a comment in the comment section. I know very well that you have something to say and your comment is valued. In fact, it's highly appreciated as well. Kindly drop it there and let us know what you have in mind. But my own take is that they should be able to transfer Mazi Nnamdi Kanu to Kuje Correctional Center, where he will be attended to very well, because I think it's someone who is alive that can be represented in the court. Then if you're not alive, what happens? My dear people, I would like you to kindly help me to share these videos as I upload them on this channel. Thank you very much. Thank you very much.